Good morning, everyone. I'm Kimberly Chalia with PHCA. Thank you so much for joining us for today's webinar presented by Eileen Dempsey. A few quick updates to share before we get started today. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for 1 continuing education credit for all attendees. For those who provided an AB number, credits will be uploaded shortly, and we'll also share certificates with those in attendance. As we begin today, all attendees will be in listen-only mode. Please feel free to submit your questions via the Q&A icon on your screen, and we'll be sure to answer as many of those questions as possible at the end of today's presentation. I'll now turn the webinar over to our presenter, Eileen.
Good morning, everyone. Thank you for attending. As you will see in a few minutes, I'm with Clifton Larson Allen. I'm a state and local tax signing director, been with the firm for about 26 years, have been working solely in state and local tax for 20 plus years. And I'm just here today to educate you a little bit on some of the issues that may impact your businesses, your entities. So what I'm going to do is share my screen with my PowerPoint, and I'm going to come off video for now, just to make it easier for me to share and look over at the slides. So I'll get ready to do that. And again, thanks for attending. Okay, so I think we're sharing at this point, and I'll turn off my video. So today, here's the agenda of the different items that we will go over and just kind of update you on some of Pennsylvania's rules. We're going to do a quick Wayfair update. The impact, I think, to a lot of your businesses is not too overarching, but I still want to give you an update on that. We'll go look at Act 45 and PA sales tax as it relates to not-for-profits. We'll also look at PA sales tax exemptions and the qualifying factors there. And then I'll just very briefly discuss some miscellaneous taxes that could apply to either for-profit or not-for-profits. So just to go over our learning objectives, at the end of the session, you'll be able to discuss the Wayfair case and the implications for your business or your entity, identify purchases which may be subject to PA sales tax under Act 45, understand current landscape for continued qualification as a PA tax exempt entity for sales tax purposes, and determine if other types of taxes apply to your entity. So we'll start right away with a Wayfair update. So I'm not sure how many of our audience are familiar with the Wayfair case, but I'll just give you a little bit of background on it. So it was a U.S. Supreme Court case that was decided back in June of 2018. The case had to do with the Wayfair company that, as many of you probably recognize the name, is an online retailer of various home products. They had been assessed by the state of South Dakota for sales tax collections that they did not make on products that were shipped into the state. Basically, the way a state formerly could assess a seller and a certain nexus on them within a state for collecting sales tax was that they had to have physical presence in the state. That was from a court case all the way back in 1973, a company called Quill. So at that time, the court decided that you had to have a physical presence in a jurisdiction in order for them to compel you to collect sales tax. Wayfair had no physical presence in South Dakota. They had no business there, no warehouses, no salespeople going into the state. So they said, no, we don't think we have nexus and we don't have to collect sales tax. So South Dakota had enacted a statute that said if you had $100,000 worth of sales shipped into the state, or $200 200 transactions, then you did have Nexus and you had to collect sales tax in the state. So it went to all the way up to the Supreme Court. Actually, what happened in South Dakota was the lower courts ruled in favor of Wayfair and said that South Dakota's statute was not constitutional on its surface. Went forward to the U.S. Supreme Court, who was asked just to look at that issue. Is this statute unconstitutional just based on the whole $100,000 of sales and 200 transactions? The Supreme Court said no, they did not rule that as unconstitutional. So on its surface, in fact, South Dakota could assert Nexus on Wayfair. They sent the case back to South Dakota courts to consider if there were other constitutional issues that maybe the statute violated. But they decided not even to bother with that because they settled with Wayfair, and Wayfair is now collecting in all states. So what happened after that? So currently, after 4 years now, Wayfair case has been around or was decided. All the states in the country that have sales tax have enacted statutes similar to South Dakota. So the criteria regarding the amount of sales, the transaction thresholds, even the definitions of qualifying sales do vary state by state. But in general, most of the states have adopted similar statute to Wayfair. So what this has happened, what's happened across the nation now is that numerous businesses are impacted by this, right? They're shipping products into all different states. And so the sales tax collections across the country have just gone through the roof, mainly because they were missing a lot of the internet sales that were happening. So with reference to a not-for-profit, obviously, as long as you've provided your exemption certificate to any out-of-state vendors, no one should be charging you sales tax. But to the event that you're a for-profit, often what's happened in the past is a business would not be charged sales tax if buying something out of state. And so a lot of the businesses would self-accrue use tax and pay that to the state. So you might want to go back, and if that's the case, and double check those invoices now that you're receiving from out-of-state vendors, and you could find that you're already being charged sales tax. So if your system isn't designed to really look at the invoice and dig in a little bit, it's possible that you're paying sales tax twice in the form of use tax if you've already been assessed the sales tax. So I think that's pretty much all that we'll talk about with reference to the Wayfair decision. So let's move on now to PA Act 45. Not sure how many people are familiar with PA Act 45, but I'm going to explain to you what that is. So if you're a not-for-profit business, most entities are under the impression that we don't have to pay sales tax on anything. However, in Pennsylvania, that's not necessarily true. And this is a very large focus of Pennsylvania audits for not-for-profits. So basically, Act 45 was originally enacted having to do with construction contractors. And construction contractors in the state of Pennsylvania, at least, still would have to pay tax on the materials they purchase and install into real property, even if they were not-for-profit, or rather, even if they were working for a not-for-profit or a government contractor. In 1998, quite some time ago, PA enacted this Act 45 that said, we will allow an exemption for the sale of what they're calling building machinery and equipment and related services to a construction company, as long as the items are used in a contract with a not-for-profit or government entity. And there's a corresponding use tax exemption. So what is building machinery equipment and what is Act 45? Act 45 is applicable to a tax-exempt entity It must have the license number that begins with a 75, which qualifies it as tax exempt. It applies to construction contracts for improvements to real property, and it applies to repairs, not maintenance. So repairs versus maintenance. So you might say, well, Eileen, you've been talking about contractors. We're not contractors. What's that got to do with us? Well, what happens is that in the case where a hospital or a healthcare facility, a CCRC, senior living community, has an in-house maintenance staff who are performing some of the operations that a contractor might perform, like doing their own repairs to the real property, possibly even doing their own installations of things like carpeting and things like that. What the state has decided is that now the tax exempt entity has stepped into the shoes of a contractor, and they're under the same rules as a contractor. So what that means is that purchases by your entity for materials that are going to be installed, like carpeting, like roofing tiles, things like that, are not tax exempt when purchased by the tax exempt entity. And this is, like I said, a very large area of exposure for some businesses or some not-for-profits that have a pretty robust staff and do a lot of purchasing of the materials. So even if they purchase the carpet or the roof tiles, let's say, by the entity, but then they have a subcontractor install them, they're still required to pay sales tax on that purchase or to assess use tax. So, so again, this is an area of pretty big focus by the state of Pennsylvania. So let me give you some examples of this whole BM&E, as they call it, building machinery and equipment. First of all, the term itself is rather deceiving in my mind, because what is building machinery and equipment? You're probably thinking of something, traditional equipment, but it's really not what it covers. So basically, the definition is generation equipment, storage equipment, conditioning equipment, distribution equipment, and termination equipment. And it's limited to the following, but this list is not all inclusive. So basically, air conditioning, heating, cooling, purification, most of the HVAC type purchases are exempt. Electrical, very limited. Plumbing, again, limited to some respects. Alarms, limited to fire security and detection. Control systems, energy management. So your whole environmental control system, that would be exempt. Traffic and parking lot and building access type things, and some miscellaneous items. So these are the ones that are under the definition of the M&A and thereby exempt when purchased. Now, here's some of the things that are not included. And as much as a few of these seem like it's rather nitpicky, I guess is the best word I can say, of the state to really go down to this level on purchases, that is exactly what they do. So what BM&E does not include is pipes, fittings, pipe supports, and hangers. Valves, big hot item on any kind of sales tax audit. Wire, conduit, receptacle and junction boxes, insulation, ductwork, carpeting, and roofing. Those types of purchases by a tax-exempt entity for installation into real property are not exempt and are taxable to the entity. Just want to bring up another document to give you an idea of exactly how precise Pennsylvania is with this. There's a document that I'm bringing up right now, Act 45. So this is used by the state during an audit to determine what is taxable that's purchased by a contractor for installation into a not-for-profit or by the not-for-profit itself. And it's separated by the type of contractor, carpentry, casework. You can find in here searching, you can go to HVAC, for instance. Whoop. And you'll see the whole area of HVAC. And then under here, you've got your taxable versus your non-taxable purchases. So this document's 54 pages long. And this is something that our wonderful tax dollars have gone to someone in the state developing this list with their citations of what's taxable and what isn't. The document is available on Pennsylvania's website, and previously it had not been, but it's now available on Pennsylvania's website. So again, just an area that many of the not-for-profits are really not aware of the fact that they could have exposure to sales or use tax on some of these purchases. Now let's talk a little bit about repairs versus maintenance. A repair in the state of Pennsylvania is considered to be a construction contract, just like a installation of a capital improvement is considered to be a construction contract. And so repairs to your real property fall under this Act 45. Maintenance, on the other hand, does not. So what is maintenance? Building maintenance, according to the Pennsylvania statute, is the performance of routine and periodic services upon a building which keeps the building in a satisfactory operating condition. The term includes cleaning, oiling, greasing, and replacing parts. So filters, things like that for your air conditioning system, they're considered to be routine and periodic. Those purchases would not be taxable. And then it goes on to say the term does not include building repair services. Okay, so what are building repair services? Here's your definition of repair. Building repair services, services to a building which do not qualify as building maintenance services or building cleaning. Not a real clear definition. So in an audit situation, there's a lot of subjective answers here that come up from auditors as to what they think is a repair versus what they think is maintenance. Just to give you one example, we had on one of our CCRCs in Pennsylvania, the issue was ceiling tiles. So they would, if you know your different ceiling tiles that you might have to replace because there's water damage or whatever, they purchased in bulk ceiling tiles so that whenever their maintenance staff was maybe changing a resident out or something along those lines, they would replace the ceiling tiles that might be damaged, cracked. So the auditor in the case decided that was a repair. That was not a maintenance. After quite a bit of discussion and back and forth with the audit manager, we finally did have a situation where we won. Our decision was that was routine and periodic. But again, so these are the kinds of issues and things that you might come up against when it comes to whether an auditor is going to interpret something one way or the other. I'm just giving you a list of some of the other things that would be taxable purchases by a tax-exempt entity, even though you have that 75 number. Examples are, again, capital purchases of materials and supplies, which are not listed as exempt under that Act 45 listing. And, okay, and I'm just indicating specifically purchases of tangible property installed that become part of real property. That's what the whole issue revolves around, capital purchases. And also because you are supposedly stepping into the shoes of a contractor for some of this in-house maintenance and repairs work, any equipment that's used for repairs and maintenance is also taxable to a tax-exempt entity in the state of Pennsylvania. So things like snow blowers, spreaders, tractors, brooms, small tools, parts and supplies for equipment, all of those purchases are considered taxable in the state of Pennsylvania. I think for now, that's about all I'll say on Act 45. want to move into another topic that seems to be becoming more of a hot topic in the state for not-for-profits. And that has to do with Pennsylvania sales tax exemption renewal. So many of the not-for-profits may be coming up, in the next 2-3 years for renewal of your PA sales tax exemption. Previously, Pennsylvania was pretty broad in its interpretation of what qualified as taxable and what didn't. But now, in the past, I'm going to say 2 to 3 years, they have been a lot more stringent on what they consider a qualifying purely public charity. So I want to go over and kind of talk about that particular area of Pennsylvania tax law. So, as many of you probably know, in order to qualify for PA sales tax exemption, there's 5 criteria that must be met. The form that you have to fill out is an REV 72, and even when you are renewing the application, you basically are starting all over because you have to fill out the entire application again. And what you'll find if you look a little bit more closely at the application is Pennsylvania has in various places on the form put questions that are basically designed to determine whether or not you meet these 5 criteria. And it's often a similar question, just in a little bit of a different way that they're asking. So it's almost like, well, we're going to ask you 3 different ways the same question to see if your answers are consistent or if, in fact, you still qualify. So, so the application, obviously, you really want to look at and make sure that nothing contradicts another answer. And, that things are pretty easily identified as qualifying for these criteria. So what are the criteria? There's 5 criteria, and you have to meet them all. It's not a 2 out of 3 or anything. It's all 5 criteria must be met, or you will not be granted exemption by Pennsylvania. So the first one is that it advances a charitable purpose. So the definition there is that the entity makes gifts of services or property for general public use, which are designed to benefit an indefinite number of persons from an educational, religious, moral, physical, or social standpoint. So we have our words that are debatable as to what do they mean. The general public use. Indefinite number of persons. What exactly does that mean? Pennsylvania will go on in one of our other criteria to broadly define what that means, but the answer still is debatable as to what you mean by an indefinite number of persons. Number 2 criteria is that the entity has to donate or render gratuitously a substantial portion of its services. Again, what is substantial? What exactly is that criteria? One of the criteria is that the services shall be provided without charge to the subjects of charity. Again, there's a little bit of a question on what does that mean without charge. As it happens within many of the senior living facilities, there's an entry fee, and then once the kind of the funds of the patient are exhausted, they're allowed to stay at the facility, and basically Medicare kicks in, or maybe some other insurance kicks in, and then the patient's not charged for anything further. So the question is, does that qualify as services provided without charge to the subjects of charity? In that case, the patient's not actually paying anything out of pocket anymore. However, the entity is receiving some reimbursement by way of Medicare or the supplemental insurance. So again, we have some terms that are really ambiguous, and what is the real interpretation of them. So when it comes to the substantial piece of it, the Department of Revenue, it says within the statute, will determine what substantial means. And it also goes on to say that it really is up to the DOR on a case-by-case basis to decide whether or not they believe that you are providing a substantial portion of the services without charge. And some of the things they consider is the remuneration that's paid to the directors and the staff. So they want to see that those individuals are not being overcompensated, and then the entity or the not-for-profit is utilizing its funds in that way rather than supporting people who can't afford to be there. And they also look at the percentage of income that's used for charitable purposes. Another factor they consider is how many individuals actually are receiving these either free or reduced charge services. So that's 2 of our 5. So now we'll continue on with, let's see what's the rest of the 3 other criteria. So the third criteria is, and some of this seems almost repetitive because the same language is included in one versus the other, but that it benefits a substantial and indefinite class of persons who are legitimate subjects of charity, which again is another, okay, well, what does that mean? Legitimate subjects of charity. So this is the way Pennsylvania defines that. Those that are unable to provide for themselves what the organization provides. Okay, some of the categories would be handicapped, aged, sick, children, and the poor. So you can have an indefinite class of persons that is the aged, senior citizens. That's an indefinite class. As long as that indefinite class is not narrowed down by things like, well, can they afford the original entrance fee? That could be something that the state could say, wait a minute, then that's not an indefinite class of people because it's too narrow. It's not indefinite. So there are the things that are basically in the hands of Pennsylvania once you submit your application to say, well, we don't think that qualifies. We don't think that you're actually giving away a substantial portion or that you're giving it to an indefinite class of persons. That's one of the key criteria that very often is where an exemption is denied because they say that you failed that test. And then another criteria is it relieves the government of some of its burden. Well, as you're talking about senior citizens who otherwise cannot care for themselves, the government would have to step in and provide some services there. So that's not generally a difficult one to hurdle to come over because there is that component of relieving the government of some of its burden. So generally, that is pretty not much an area that is challenged, at least within the area of healthcare. In some of the other not-for-profit type entities, that may well be a concern. And then the last criteria is that it operates entirely free from private profit motive. For the most part, a 501c3 organization, their articles of incorporation and their operating agreements certainly do have that criteria in there that it is free from profit motive. So again, that's not typically a problem. However, what I believe a lot of businesses are under the assumption that if we are a 501c3, we'll automatically qualify for PA sales tax exemption, and that's just not really the case. It is the case in many of the other states, but Pennsylvania is pretty strict on its application of this Purely Public Charity Act. And actually, they've been getting a lot more strict in the past years. So we've seen a trend on the entities that are applying for application for the sales tax exemption. We're seeing a trend toward the exemption not being allowed and having to go forward to an appeal to see if you can get it at that level. So recently there has been a court case that was decided back in October of 2021. I believe it is still under appeal by Tower Health, but it was Chester County versus Tower Health. This had to do with a property tax case. However, the exact same criteria of purely public charity, that exemption, those 5 criteria we just went through, is the exact same criteria that is used to get exemption for sales tax and property tax alike. And I'm sure that many of you have seen that, in your own entities. So that's the reason why I'm bringing up the case, because this case then might flow right down to a sales tax exemption denial as well. So just as a matter of numbers, more than 75% of all hospitals, at least in PA, are not-for-profits. I'm sure the numbers are quite the same for the senior living facilities, but the bottom line is that the majority of the healthcare hospitals and senior facilities are in fact not-for-profits in Pennsylvania. So if you think about that, that's a lot of revenue that the states are not getting from those types of entities, probably more in the area of property taxes than sales tax, but both are very high levels of taxation that are being missed by the state because so many are not-for-profits. So the case had to do with 3 of the Tower Health hospitals that were located in Chester County. And at the end of the day, the ruling was that Tower Health failed to provide uncompensated patient care. Reason was that the Medicare and the private insurance, in the eyes of the court, that was the argument by Tower Health, was that the Medicare and the private insurance was less than the hospital charges. And so therefore they were providing that differential as uncompensated patient care. And the court in this case ruled that undercompensated care is not uncompensated care. So again, we're back to that whole idea of, is the business, is the entity providing uncompensated services to its residents? They also went on to say that master charge sheet that they would have in a hospital for here's how much everything costs is basically just to follow the guidelines by the federal government. And in fact, it's meaningless. Not ever really are those charges the charges. Even the insurance companies, as you know, when they might put in for reimbursement at such and such an amount based on this master charge sheet, but it's always reduced by the insurance company. And then, there might be some further reduction even after that. So the bottom line is that this court decided that that was meaningless, and that was not any proof that in fact Tower Health was providing uncompensated care. So what does it mean for not-for-profits who might be coming up for renewal on their sales tax exemption? Some of the other considerations that led to the decision that Tower Health, in fact, did not qualify for these 3 entities as tax exempt was the administrative structure. Tower Health has their parent organization that provides management for the various hospitals that are under the Tower Health umbrella. And that administrative structure of management fees being charged to the hospital. In many cases, they felt was what was causing the hospitals to have a loss in their business, because the management fees being charged were exorbitant, in large part because the monies that they were charging was then being given to the executive compensation. And so following the whole thing through the system, he said, no, this entire structure is what a for-profit entity would follow, not a not-for-profit entity. And so with all that in mind, we think that Tower Health is really operating as if it's a for-profit, not a not-for-profit. So I think what many of the entities might want to do is to have a little bit of a checkup, looking at the substantial amount of free versus reduced fee services is probably the key point to what you want to look at. Just so you know, Pennsylvania's criteria previously for approving applications was if they had somewhere between a 5 to 10% of their services were given for either free or a reduced fee, they accepted that and they qualified you as exempt. They have now pushed the envelope up to the point of somewhere between 20 to 25%. And I've had discussions with the Pennsylvania Department of Revenue on this, and that is their unwritten criteria at this point for exemption. So you want to look at the number of people that are served versus the number of people that get either free or reduced services. You want to look at the percentage of income versus expenses. Again, on the application, the REV 72, there are several places where a similar question is asked. And definitely you need to look at, are we being consistent in what we're saying, and do the numbers, meet the now enhanced level of free services and for our business or our entity to be approved once again for tax exempt status. And again, this would imply if you're not exempt for sales tax and you don't get that 75 tax exempt number, you are likely not exempt for property taxes either. So it's definitely got a fairly large impact on the not-for-profit businesses. Okay, and so I think for now that's about the extent of what we'll talk about with reference to exemption certificates. There are also some miscellaneous taxes. So for any businesses that are located in Philadelphia or have any kind of operations in the city, if you've got 990T income, that income is subject to the Philadelphia BERT tax. So I know a lot of businesses think, again, we're tax exempt, that means we don't have any tax. But even at the federal level, you do if you've got unrelated business income. So to the extent there is unrelated business income, that would be subject to the Philadelphia BERT tax. Pittsburgh also has an institution and service privilege tax. It's basically a gross receipts tax, very similar to a BPT, but they're not calling it a business privilege tax because it's an institution rather than a business. Interestingly enough, I find it interesting that Pittsburgh actually assesses this tax, given that Pittsburgh no longer has a business privilege tax on for-profit entities. So it's interesting that they've decided that they will tax a not-for-profit with 990T income, but they're not taxing a for-profit business on their gross receipts. Again, I'm not always privy to the legislators in the different areas and what their thoughts are, but this institution and service privilege tax is a gross receipts tax. It's a tax on 990T income, but you do have to prove that you're a purely public charity to not be subject to this tax. So Again, you have to provide to the city of Pittsburgh your approval from the state of Pennsylvania that you are in fact a purely public charity. So just keep that tax in mind. Harrisburg and other local jurisdictions do have gross receipts taxes, and while they do not apply to a not-for-profit 501c3, in most cases they accept 501c3 status as opposed to the purely public charity confirmation, that you are subject to gross receipts tax again on 990T income. It's interesting, Harrisburg has been, maybe for the past 5 years, sending out, and I don't know whether or not any of the not-for-profits online here had received any, but they were sending out Nexus notices to several of the not-for-profit businesses wanting to assess tax on 990T income. We had several of them. I talked with the attorney in the city of Harrisburg that was pushing this program. And in most cases, the gross receipts tax that they were ending up collecting was less than $1,000 on an entity in a year, and most of it was even under $500. And I said, how much time and energy are you expending trying to collect $250 from a not-for-profit entity because they didn't file this return and they have 990 income from advertising or for some other UBIT subject? And his reply simply was, we have a lot of not-for-profits in Harrisburg, and we're going to collect everything we can. So, so that's pretty much what that jurisdiction said. And there's various local jurisdictions in the state of Pennsylvania that would also take the same position of taxing 990T income for their business privilege or gross receipts tax. Again, the rate's not large. It's generally not a lot of money, but a lot of the jurisdictions are getting very active in looking for new businesses to add to their ranks of taxpayers. So they're the things that you need to keep in mind. I'll open up for questions in a few minutes. I just want to kind of give you some idea of who CLA is and what services we could provide in the event that any of these situations happen. Again, we are a full service, what we call professional services firm. We've got offices across the country. In the state and local tax arena, we've got about 45, 50 full-time professional SALT people, one of which is me, and do quite a bit of work in not just the not-for-profit, but the for-profit area. We assist in sales tax audits. If your business is being audited, we can represent you. We assist in, we've done several capital purchases reviews where we can come in, look at your capital purchases for the last 2-3 years and figure out if you've got any exposure in that area because of this Act 45, and then discuss possible options you can put in play to mitigate that, one of which is a voluntary disclosure agreement with the state. So there's some various things that certainly we can do to help, and any kind of consulting that you might need. They're the types of things that we would be glad to help you out with if you need it. I believe the PowerPoint presentation is going to be put up online, and so you'll have my contact information there. And so I guess at this point, if it's good with you, Kim, I'll open it up to questions. I haven't had a chance to look in the chat and see if there's anything in there, but do you want to check and say?
Yep, certainly. I did put a note in the chat reminding everyone that if you do have any questions, please submit those via the Q&A icon. I'm going to pull that up now and just see if we've had any. We have not had any questions come through. I'll give everyone another moment or two to submit a question if you have one. If you prefer to submit your question privately, you're more than welcome to email myself or Eileen after today's session.
Right.
And we'd be happy to answer that at that time. Eileen, I thank you so much for, whoa, we got a question from Kathy. Eileen, are you able to open the Q&A icon? Do you see that question?
I am, yes. Is there a process to dispute the loss of the exemption? Yeah, Kathy, thanks for that question. Yes, there is. Basically, you put in your REV 72 application, and the Department of Revenue reviews all the documents. Almost always there's some kind of a question that you'll get back from the Department of Revenue asking for maybe more information or to clarify some information. So again, that's one of the other services that we can certainly help you with, is to either help prepare the application or review it before it gets submitted. But so that's what the Pennsylvania will do. If they determine that in fact you do not qualify, you will get a decision from the Department of Revenue that says, you've been denied, and they will tell you which criteria you failed according to their review. And then you can file a petition with the Board of Appeals to either supply more information or ask them to consider this argument or that argument. And the Board of Appeals has to rule within 6 months of you submitting your petition. It's an online petition. It's a form REV 65. So they, within 6 months, have to rule. I'll tell you that most of the time they are not looking at it before a couple months of that due date, and very often are within a 30-day window when they actually will send you a decision. If the Board of Appeals also decides that in fact you've not met the criteria, you then can go to the Board of Finance and Revenue and file a petition with them. That is made up of an independent panel of, it varies, but of generally 4 either attorneys or outside practitioners, who then would review again. That can be done either through, now they will have in person out in Harrisburg where you can go and attend a hearing. It's a public hearing, so you are in front of, the whole docket of people who are on the docket that day. Or you can do it via telephone or web on screen. Or you can just submit your arguments and say you want them to rule without any hearing. If you lose at the Board of Finance and Revenue, the next step would be Commonwealth Court. So obviously, you want to try to substantiate your position before that. So hopefully that answers that question. What I usually, and what we usually advise people is, at that point, when you're getting down that road of appeals, you really want to look at what is the impact to us from this denial. But as I said, prior to the Tower Health case, again, which is on appeal, it was limited to what your sales tax exposure was. So what really are your purchases that you are able to have tax exemption on? But now, if you want to consider the property tax implications as well, it could be something that's, really giving you the drive to move forward. So.
Thanks, Eileen.
You're welcome.
If anyone has any additional questions, please submit those. And like I said, we're happy to answer questions via email as well. And all right, well, I think that we'll give everyone back 12 minutes of their day. Eileen, thank you so much.
You're welcome.
We look forward to having you back again.
Thank you. We appreciate the opportunity. Thank you.
All right, thank you.